And we're live.
Okay. Well, welcome to this presentation, everyone. We're delighted you could join us. This is one of a series of customs updates on hot topics impacting the global trade and customs industry. My name is Dan Kisselback. I'm a partner with Miller Thomson in Vancouver, and I am co-hosting this presentation with Dave Pentland. I lead the Trade and Customs Group at Miller Thomson, and today's topic is Bill S-211 and its impact on global apparel supply chains. The act is named Fighting Against Forced Labor and Child Labor in Supply Chains. And of course, because we're a law firm, we provided a little disclaimer here that we're not providing legal advice. And if you need legal advice tailored to your situation, please consult with a licensed professional. Next slide, please. Over to you, David.
Yeah, good morning, those of you on the West Coast, and good afternoon to anybody on the East Coast joining us. I'm happy to join Dan again on this important topic that hasn't got a lot of media play or industry play, so I think it's very worthwhile. I'm the Vice President of Compliance and Client Services at Carson International. We're a Canadian and U.S. customs broker, and I'm a licensed customs broker in Canada. So happy to join you again, Dan.
Thanks. Well, yeah, I have 30 years of experience in the legal side, practicing law in the area of global trade and customs. I'm licensed in New York, Ontario, and BC, and I'm now trying to join Dave Pentland's ranks as I've passed the CBSA Professional Customs Brokers Licensing Exam. So we just thought we'd put out a little kind of ditty here. Never pick a fight with people who buy ink by the barrel, Mark Twain. So generally the idea is it's a bad idea to argue with someone who wields power and influence, such as the newspapers did in the olden days. Now here the government wields a lot of power and has garnered a lot of support for this legislation that we're going to talk about. I would call it a juggernaut or a steamroller, a huge powerful force. And the move is being towards legislation designed to remove child labor and forced labor in supply chains. And this is part of a social movement in Canada and the US and elsewhere. At the last sitting of the House of Commons on March the 6th, John McKay noted that the proponents of the bill are at the end of a 4-year journey, and hopefully they think this will be put to a vote quickly, and Canada is hoping to be a leader in this type of legislation. So this is the underlying animus that's pushing this legislation forward. World Vision used its considerable resources to call attention to the social problem that the bill was designed to address, and that Canadians had been playing an unwitting role in enabling the distribution and consumption of products produced from forced labor and child labor. So McKay noted that this is really a citizens movement, and the movement has pressured Canadian political parties to commit to the legislation. So Canada's efforts are consistent with a broader worldwide effort. As we often do, we compare our situation with that of our friends and neighbors down south and see how the U.S. has approached the issue. The U.S. Bureau of International Affairs keeps lists of goods and sources that it has reason to believe are produced by forced or child labor. And this is required under the Trafficking Victims Protection and Reauthorization Act.
And Dan, I think this is worth noting that this is not a new thing. The United States, this act came in 2005, and it's just that they put more teeth in the legislation in the States. So,
yeah. And so there's a comprehensive, if we can just go back one slide again here, there's a comprehensive list of goods produced by child labor, forced labor, comprising of 159 goods from 78 countries. So it's been a subject of a study, and I imagine it changes quite regularly. So on to the next slide here. The U.S. strategy and interests. The publication of the list provides new opportunities to engage with foreign governments, to talk to foreign governments about what's going on in the world. And it's a resource for due diligence purposes for persons who want to complete risk assessments to manage the issue, to manage forced labor and child labor produced goods out of their supply chains. And procedural guidelines have been published for the development and maintenance of the list. David?
Yeah, and something to note is that these procedural guidelines are used both by trade and by U.S. Customs. So if you're bringing products in from China and it's coming in from the UGAR region, U.S. Customs will be they target those goods because those goods are in the guidelines that they're well, right now you're not allowed to bring in goods from that region, but also it's the one that identifies where U.S. Customs, I'm talking about, puts their resources to looking at products and or goods from countries that are that have issues in the past or have been noted of to be looking at them. So.
On to the next slide. Yeah. So there's a patchwork of different pieces of legislation designed to get at this particular issue in the U.S. And the Uyghur Forced Labor Prevention Act is one of them. It was signed into law, and it supports the CBP's enforcement of Section 307 of the Tariff Act of 1930, which prohibits the imports of goods produced through the use of forced labor. And it establishes a presumption that goods produced in the Uyghur region are produced by certain entities is prohibited entry under the Tariff Act. So that it raises this presumption. David?
Yeah, and worth noting is that if you bring in from that region, you're presumed guilty, and it's up to you to prove that otherwise your goods have not been produced by, which it holds a very high bar when you can't challenge U.S. Customs on it. Really, it's really up to you. And so what's happened? They're trying to reduce almost all imports from that specific area. So it's I've seen many brands now just abandon bringing goods in there. The unfortunate thing is that that area of the world is a huge producer of certainly 100% cotton and also wool. So there's a big area. So
Yeah, so it's kind of hard once you've imported or attempted to import the goods to try to go back and figure everything out. But it's slide 9. We say that the presumption can be technically, I guess, set aside if the commissioner of U.S. Customs determines that the goods are not produced with forced labor. It's a rebuttable presumption, but if you're in Canada or the United States, it's kind of difficult to do things from a remote control situation. I think that's your point, David.
yeah, yeah, totally. And a good thing is the next slide. Actually, if you go to the next one, the U.S. is very proud on what they've done. So that dashboard link is actually all the statistics on shipments, and they're pretty proud to show you that they've stopped and held literally thousands of shipments, forcing importers to prove that those goods are not the result of prison labor, child labor, any kind of forced labor. So it's the United States has really taken the lead on this, and so everything, very much of it's available. And the reason we're going into this is to show you the difference between what the United States has done and what Canada is proposing under the new bill.
So in a kind of a nutshell approach, they applied approach to administration and enforcement, prioritizing the highest risk goods, and it's based on current data and intelligence. And the highest risk goods include goods from the Uyghur region and the entities on the Forced Labor Prevention Act list. So I would characterize it as a system of prohibition, right? Prohibited entry.
Right.
So it's a little bit different than what we're going to see in a minute when we go through the legislation that is applicable to Canada. On to the next slide, please. So again, the statistics dashboard, Dave, do you want to speak to that?
Yeah, again, these are just all active links that you can take a look at what enforcement has taken place, the release orders that they put in place, and also there's an entity list on there that was on the previous slide. If you're importing in the United States, you're expected and actually you're mandated that you must look at this list to make sure you're not buying from any of those countries or companies listed on that list, because categorically those goods are not allowed into the United States, period. And so it's, the last thing you want to do is have an entire container arrive at Port of Long Beach and sit while they put a hold order on it, to only find out 60 days later that those goods aren't allowed in and you're subject to demurrage and loss of cargo and loss of sales, etc. So people have a list they can actually go to and look at it, and it's importers in the United States are doing their due diligence to ensure that they're not buying goods that are targeted by U.S. Customs.
Yeah, and so your options are not good, right? I guess you have to decide if you want to export,
Yeah.
return them back from the originating country.
Right.
So it's I just wanted to pause to mention that in the U.S. it looks like the government has taken a more task force approach, where it's a multi-agency responsibility. Whereas in this bill that you see, the minister responsible is public safety and emergency preparedness. So onto the bill that we're talking about, Bill S-211. I would describe it as a supply chain transparency, compliance, education, or imperative, and a due diligence bill. Right, those are really the points that come across to me as what is it? It's going to require certain entities to examine their supply chains, and in that process, the government's providing an educational function, and the entities or government institutions will have to certify that they are not involved in the importation of goods that are produced with forced or child labor. And if products are made with forced or child labor, they will have to state what remedial or corrective measures will be put in place to avoid this. And the legislation, as I mentioned, is designed to educate Canadian business and government entities about the issue, require companies to look deeper in their supply chains to understand if their supply chains are connected with this problem of forced or child labor, and help ensure that Canada and Canadians do what is necessary to fight against forced labor and child labor in supply chains. David?
Yeah, and it's worth noting that this is not a brand new bill. This bill has already received first and second readings. It's set up to do third readings. Most bills are amended in the first or second reading, and so once there's been no amendments to what we're going to talk about. So in the third reading, looks like it'll become law, and then it just needs royal assent, and then the act is passage of the act creates it as law. So we're already down the path here, and again, when I previously commented, there's been little of this in the media, and once we get into the reporting, you're going to see that there's another level of reporting that everybody's going to be bound to. So I would say.
All right, so on to the next slide. Who is caught by the legislation? Well, government institutions, it was said that it would be unfair to capture corporate Canada without also capturing governmental institutions. So governmental institutions are caught, and that's a defined term. We might go into that in a minute. Certain Canadian linked entities that produce or import goods, and Section 3 of the Act sets out the purpose of the Act, which is the imposition of reporting obligations on government institutions and what they call entities. Section 5, Part 1 deals with government institutions. Section 9, Part 2 relates to entities. David?
I think it's worth going to the next slide. And also in the wording there, you have to see that you don't have to be a Canadian company. If you control an entity engaged in these activities, you're still bound by the regulations as well.
Yeah.
So there's a lot of non-resident importers that aren't in Canada. They'll still be bound by these reporting measures.
So this slide kind of tracks Section 9. It's including any entity that under 9A produces, sells, or distributes goods in Canada, or 9B imports into Canada goods that are produced outside of Canada, and has these qualifiers: at least 20 million in assets, generated 40 million in revenue, or employs an average of at least 250 employees. So you have to be two of those. And the meaning of the entity may also be prescribed by regulations. The Act provides for regulations, so from time to time, you'll probably see, if and when this legislation is passed, regulations that are created and made by the minister. It also, the Act provides for a review, a potential review later, 5 years from now, on its effectiveness. On to the next slide. So reporting requirements. This is really where the rubber hits the road, I think, David.
Yes.
Yeah. The annual report that it calls for is each entity must, before May 31 of each year, report to the minister on the steps that the entity has taken, and the same sort of thing applies to institutions, government institutions, during the previous financial year. So you have to go, it's kind of like a tax report in a way, you report, self-reporting, self-assessing system. You go to the minister and you say, here's my information with respect to how the entity has taken steps during the previous year to prevent and reduce the risk that forced labor, child labor is used in any step of the production of the goods in Canada or elsewhere, or of any goods imported by that entity. And it may be a single report for that entity, or it may be a joint report respecting a group of entities. David?
Yeah, and I think it's worth noting that this bill will probably not get royal assent and become an act until after May 31st of this year. So I don't think anybody needs to panic right now. It'll be later in the year, but it will most likely be in effect for next year. So you'll have to submit a report regarding this for next year in 2024. So
yes, and there's an in-force provision that will tell us when the legislation will be brought into force. It may be brought into force at the beginning of 2024. But anyways, so it is coming. We believe it's imminent. It's just a matter of when the legislation will be brought into force, and so there'll be an opportunity, likely, for a bit of ramping up to ensure compliance. So the reporting requirements, government institutions are also caught. As I mentioned, it was thought that was a fair way to go. These terms, entity and government institution, are defined terms under Section 2. And for government institutions, essentially the term has the same meaning as it does under Section 3 of the Access to Information Act. So if you want to drill into which government entities are caught, that's where you go. David?
I think it's worth noting it, and I don't think we have it in our presentation, but I found out from some reliable sources that these reports will be made available to the public. So I'm not sure what sort of vehicle, if it'll be through Statistics Canada or from CBSA, but they're noting that they'll be made available. So a word of caution as we walk through what they're looking for. This may be where you need to take it serious, but less will become more because there's certain things that people do within their supply chains that they may think they have competitive advantage. So I think it'll be where you'll report what the government needs to see, and that you're taking careful eye on ensuring that there's no forced labor in your products or vendors you're buying from, but you may not want to go into great detail. So.
Yeah, so that's you're bang on. It's part 3, general, under the heading registry. There's an electronic registry, and it says under section 22(1), the minister maintain must maintain an electronic registry containing a copy of every report or revised report provided to the minister under section 6, 7, 11, or 12. And then it says accessibility to sub 2. The registry must be available to the public on the Department of Public Works and Emergency Preparedness website. Public safety, I should say, and emergency preparedness website. So there you have it. I mean, and that's kind of, I guess, going to encourage people to report the right thing, right?
Yes, and they also noted that you'll be asked to make this available on your website as well.
Right.
So, I was talking to a major brand this morning, and, I'm starting to believe this is going to be like the green initiative where you can actually turn this into proud to be ensuring that your brand is part of, making sure that globally your brand doesn't use forced labor, et cetera, like that. So I think, and when we walk through this, I think there'll be a lot of board of directors taking a big pause and saying, well, let's take this. If this is going to be another burden on our company, then let's at least, I don't want to use the word spin, but I will use the word spin it so that it's in our favor in the brand, that you're actually a conscious green company, but also you're ensuring that there's no forced labor that is being used to make our products. So
yeah,
my comments only. So
yeah, no, I think that's a good point. It fits within the ESG, good governance positioning for corporations, and because it's required, and it's an offense to make a misstatement. Um, that's the carrot part of it. There's the stick part that we'll come to in a minute, but there is a carrot and a stick to this. So just going back, the coming into force section, that's under section 28. The act comes into force on January 1 of the year following the year in which it receives royal assent. So there's going to be a little bit of time to get ready.
okay.
So let's go on to supplemental information. So this report has to include a bunch of stuff and information regarding each entity, including, and you'll see here the list, the structure and activities in supply chain, policies and due diligence, parts of the business and supply chain that carry a risk, any remediation efforts respecting the use of forced labor, remediation efforts designed to offset lost income to vulnerable families, training provided to employees, how the entity assesses its effectiveness in avoiding the use of forced or child labor produced goods. So it's a pretty comprehensive list, right? And I pause to mention that under section 23, there's ability to make regulations. So this list could be, developed or shaped in a manner and form requirement specified by the minister, I suppose. And as I mentioned earlier, section 25 indicates that a parliamentary review can start at the 5th year after the day in which the section comes into force. So the government can, from time to time, review the legislation, see what's working and what's not working. David?
Yeah, I guess until we see exactly what needs to be reported, this is kind of a generic list, but it'll be interesting to see when it comes out exactly what they're asking for. So, but well, time will tell.
Yeah, and we'll get into like how do you approach this issue at the end of this, in terms of proactive steps you can take at this point. And I would just characterize it at this juncture to say a gap analysis. Assess your current state. What's your desired future state? What's the gap? How to fill the gap. So on to the next slide, please. So they've defined child labor under Section 2. And it's labor provided under circumstances contrary to Canadian law. That's 2A. 2B is under circumstances of mental, physical, social, or morally dangerous conditions. C is interfering with schooling, or D, which they describe as constituting the worst forms of child labor under this particular convention. So there's a convention on the worst forms of child labor. So it tells you what constitutes child labor. Forced labor, again, Section 2 is a defined term. It's the type of labor that could reasonably be expected to cause a person to feel threatened, or constitutes forced or compulsory labor under the convention. Again, there's a forced labor convention. So on to the stick part of this legislation. Each piece of legislation generally contains enforcement provisions. They may be civil and they may be criminal. In this situation, there's a bit of combination of both. Section 19 of the Act indicates that if you fail to comply with certain sections, you can be convicted of a summary conviction offense and liable to a fine of up to $250,000. Subsection 19.2 says that it's an offense to issue a false or misleading statement. So if you don't tell the truth about what you've done or your due diligence or whatever, then that can get the company or any director or officer or agent in trouble, because Section 20 indicates that a person can participate in an offense committed by the underlying entity if they acquiesce or participate or direct in the offense. So there's a director's liability provision, and that will probably be of interest to boards of directors and senior officers and agents that are operating a business. David?
Yeah, I think it's well noting that we may not have a lot of directors, presidents, vice presidents of businesses on the call, but it's this group needs to go up the chain and tell these people that Section 20 of the Act really holds them liable and responsible. So I think it's got to go up to the boardroom. They have to mandate it, put some, certainly the bigger ones have got to put some teeth behind what they put together and understand it, and then delegate. And because, they're the ones ultimately are responsible.
So next slide, please. Corrective measures. Enforcement. Section 15 indicates that if the responsible minister is of the view that an entity is not in compliance, the minister may require it to take corrective measures. So there's a civil directory function or power that exists within the Act. Additionally, there's administration and enforcement powers that are usually used. They're tools in the toolbox that investigation and enforcement officials use to investigate offenses. And they include power to enter a place and gather evidence. They may require, under this Act, the enforcement officers may require the owner or person in charge of the place to provide assistance. So they may be asked to, show us where the computers are and where's the server and where's all the information, that kind of stuff. And under one of the provisions, 15 sub 4, officers can get a search warrant to, in fact, search a dwelling place. The home of an officer, a director, or an agent, for example, might be searched. So there's pretty significant powers within the act to go ahead and enforce it. Um, and so it's not a toothless tiger. On to the next slide. So we think in our respectful submission, it's a good time to consider due diligence and prepare a checklist tailored to your business for this legislation, because it's, all indicators are it's going to be passed shortly and then brought into force. One of the things that is important in any system of compliance that I have seen is to get buy-in at the corporate board and directors level, so that adequate resources can be assigned to the issue, and a plan of action, an action plan can be developed to deal with the thing. And then, as I mentioned before, what I would think of this is a kind of a gap analysis. Identify where the business is at the current state, what's its desired future state, that is managing any of the forced labor or child labor products or goods out of the supply chain. And then, is there a gap? Maybe there are issues of risk. Maybe goods are coming out of a region where there is a large use of forced labor or child labor, and then take measures, identify the means and ways in which you can fill that gap, deal with that problem, manage the problem out of the system. David?
Yeah, and it's worth noting that the second point there is part of this. The act right now just talks about forced labor, so they've changed the wording to include child labor. And so if you went back to the definitions, child labor is anybody under the age of 18 that's being kept from attending schools. And so there's going to be a little bit of gray area where there have been, child labor markets where youth that have dropped out of school and have decided to leave school and started working in a factory in maybe the southern United States. Now, is that going to be deemed child labor because they're by working they're not attending elementary school, and just because they're 16, 17 years old? So I think that's going to be a bit of an issue that we're going to have to wrestle with a little bit, or because it's just not something that's happening with forced labor in China. This actually happens in the United States. So I don't know, that kind of makes me pause a little bit, that we're putting the term in there and we've defined child labor as anybody under 18 that's not going to school. So I don't know. We'll have to wait and see what happens there.
I would imagine that we'll likely as well, beyond the regulations, see some policy guidance, hopefully.
Yeah, I hope
With
so.
respect to issues such as economic sanctions and export controls, there's been various degrees of policy statements being issued, but this may be another one area where memoranda or something is going to help clarify the issue.
Right. Yeah, because I've talked to one of our clients, and they're just saying, so if I reach out to my vendors and have them ensure that nobody is under the age 18 that's being kept from going to school, working in their plants, and what happens if they say, no, we've got a pool of people that, they left school and they're active, they're over 16, and they work in our plants. So what happens in those cases? And I just said, I can't tell you right now. So.
On to the next slide. So, we have suggested that there are steps that can be taken now, mapping the supply chain, identifying risk areas, identifying good internal controls and compliance reporting systems, creating a system for correcting issues, and preparing a communication system to ensure that suppliers and other stakeholders are on side with your compliance plan. David?
Yeah, and also I think when we put this together, we actually were targeting the apparel businesses because they seem to be affected. This is not just apparel. This is any importer in Canada that's importing goods that fits the term of entity. So if you're an SME and you're under the threshold of an entity, it's not an issue that you'll have to report on it. But if you're any importer, regardless of if it's apparel or not, you'll be bound by the new act. So
Yeah, so it's nice to have this goal, but as the author of The Little Prince said, a goal without a plan is just a dream. So you have to take it to the next step and kind of develop that action plan that is tailored to your business. Next slide. And so that's all I have to say about that. David, do you have any final comments?
my final comment would be, I would say everybody should make themselves aware of what's going on. Certainly, if you fall into the entity category, especially major brands, I would say that they're probably going to look to make an example out of somebody when it first comes in that doesn't file. And so I think it's just beware, stay informed, and stay on top of this. I still think, maybe to me, my personal thoughts is it's a little overboard as being in Canada where we forcing people to report versus having it on a complaint basis, or being like the United States where they publish directives and they publish bad actors in that space. Now it's everybody has to file a report. So there's a whole new level of bureaucracy that's involved, and I guess we'll have to hire some experts with our government agencies that are involved in this. So it to me it's a little overwhelming, and unfortunately it's too bad that we're just getting involved when the bill has already passed two readings. But I guess stay informed and be aware, and we'll see what happens next. So
Yeah. So with that, I want to thank you for attending. I wanted to let you know that we will be putting out our survey for this particular event. I think Gus is going to give us a link, giving you the opportunity to provide your input and ideas as to what is useful and what you would like to see more of, and maybe where we should concentrate our efforts. We want to provide content that is useful to you and that you consider valuable. So please fill out our survey. I also want to put in a little plug for our YouTube channel. We have recorded a number of these different events on YouTube, and they'll be available to you. And Gus or one of our folks can provide you with that link. So once again, thank you for attending. Really appreciate your involvement and participation. And don't hesitate to send either one of us, Dave or myself, an email or give us a call and let us know if we can answer any of your questions. Thanks again, folks.
yep, thank you. Take care.